we have a great news here, and I thought I should share it. U.S. ends policy of denying citizenship to children born via IVF or surrogacy. And we know back with this is an article for NPR, and NPR is really good. It's NPR political. They're really good when it comes to immigration articles as well. So they're pretty good. And this came out on May 19, 2021, yesterday actually. So what's going on? What's going on is that the State Department will now approve U.S. citizenship for children born abroad to same-sex or heterosexual American parents via in vitro fertilization, surrogacy, and by other assisted reproductive means. We know that with modern families, sometimes it's really difficult to have a child as a really the way naturally. So people use different techniques to actually have a child. So either in vitro fertilization, surrogacy, or by other assisted reproductive means. And if one of the parent is a U.S. citizen, in the past they were really prevented, especially under Trump, they were prevented from getting U.S. citizenship, even though a parent, one of the parents or both parents were U.S. citizen. But now, under this current administration, they have came up with the end of that policy. Okay, so basically, under the policy announced Tuesday, the child must be born abroad. This is for children being born abroad. Okay, to married parent, and at least one of the parents has to be a U.S. citizen. Okay, the child must have biological ties to at least one parent. So basically, they're just going back with in vitro fertilization, surrogacy, or by other assisted reproductive means. As long as you have a child that was born abroad, and then one of the parents by those means, right? And then one of the parents is a U.S. citizen. So in the past, those children were prevented from acquiring U.S. citizenship, but now they can. And basically, the only reason they're doing that, they are going to update the application of the Immigration and Nationality Act, basically taking account the reality of modern families and advances in assisted reproductive technology. So they have to take into consideration the reality of modern families, and because we have advances in technology and people are having children by other means, okay, and they cannot be penalized just because they were born abroad and they were born by not the common way. And not to mention, one of the parents a U.S. citizen. Why should they be excluded? Okay, so they went ahead and updated this Immigration and Nationality Act, INA. So the new guideline reverses a long-standing rule that considered children born outside of U.S. to a surrogate to be born out of wedlock. So they had to go ahead. This is a long-standing rule that basically, if you were born abroad to surrogacy, they will consider those children as born out of wedlock. So even when the parents were married, that's so sad. Even when the parents were married, born out of wedlock, just because they didn't come about in a way that we know, right? So those are means based on technologies, based on advanced science, and pretty much they were really penalized. But now they can go ahead and claim their U.S. citizenship. So that's what I'm saying. And if you go here, it goes again, and then under the old standard, several same-sex parents have filed lawsuits to have their children declared U.S. citizen. The Trump administration lost 2 federal cases as many years over the issue. So basically, even same-sex parents, they were claiming the same thing, and then they filed lawsuit. So In June 2020, a federal judge ruled that the State Department must recognize the daughter of a same-sex couple as a U.S. citizen since her birth in Canada via a surrogate the year before. Again, this is for children being born abroad by way of surrogacy, in vitro fertilization, and in any other assisted advanced technology. And previously they were prevented from claiming U.S. citizenship, but now this current administration has actually ended that policy, so they can actually claim that policy. Okay, so they give an example. One child with genetic tie to the U.S. citizen father was granted citizenship, while his brother with tie to his Israeli born father was denied citizenship. You see that? The judge in that case ruled in 2019 that the child is a U.S. citizen because his parents were married at the time of his birth, and therefore the State Department misapplied the law. Okay, so that's what's going on. But this new policy, basically the new policy, is a remarkable moment for LGBTQ families who fought the U.S. Department unconstitutional policy. So most people from the LGBTQ fought the U.S. State Department because their policy were really unconstitutional and based on equality. So what are you going to do? You just have to grant those children U.S. citizenship, even though they were born through surrogacy, in vitro, or other advanced technology techniques. Okay, this one is basically communities united pushing back against discrimination. So any type of discrimination, people, when they fight, they fight hard, eventually they win. So this is a big win, really. US ends policy of denying citizenship to children born via IVF or surrogacy, and this is really good, especially for parents struggling to give birth. They are using other means to give birth. They cannot be penalized. Really, their children cannot be penalized if one of the parents the U.S. citizen. I don't see why they should be penalized, and this has changed that. Okay, that's all for the good news, and I think it's a good news, especially if the child is here without proper documentation. Really, come on now. So this is a good news. Okay, I'm gonna end with this one again. Like, share, comment below. We are still trying to reach 10,000 subscribers. Come on, just share, keep sharing. Really appreciate that, and I promise I will do the live answering your questions basically once we get to that 10,000 milestone. Okay, Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area, and this was US immigration. Until next time, bye bye.